So the U.S. Supreme Court is now at the center of a clash between state consumer protection powers and the First Amendment claims of anti-abortion crisis pregnancy centers. The case, First Choice Women's Resource Centers v. Platkin, comes out of New Jersey. So in 2023, Attorney General Matthew Platkin opened a consumer fraud investigation into whether First Choice, a Christian network of pregnancy centers, misleads people into thinking it offers abortions or comprehensive reproductive health care, when in reality, it does not. The investigation focuses on advertising, online content, and what staff actually tell people once they walk through the door. Platkin's office issued subpoenas demanding years of internal documents, advertising materials, counseling, scripts, staff, communications, and the names and contact information of doctors and thousands of donors. First Choice, represented by the conservative legal group Alliance Defending Freedom, sued in federal court, arguing the subpoenas are so broad they chill its speech and scare off supporters, violating the group's First Amendment rights to free speech and association. But a federal district judge dismissed the case as premature, saying First Choice should raise its constitutional objections in New Jersey's own courts if and when the state tries to enforce the subpoenas. The Third Circuit Court of Appeals agreed, and now the core question before the Supreme Court isn't directly who is lying about abortion, it's whether organizations like First Choice are entitled to a federal forum immediately when they say a state investigation is chilling their rights before any enforcement actions happen. During oral arguments, justices across the ideological spectrum signaled concern about the scope of the subpoenas and their potential to intimidate donors. Even some liberal justices pressed New Jersey on why it needs such sweeping access to internal communications and donor data to investigate whether advertising is deceptive and whether ordinary donors would really understand the fine distinction between an administrative subpoena and a court order. Abortion rights advocates and consumer protection groups counter that if the court makes it too easy for crisis pregnancy centers to run to federal court, it will hamstring state efforts to police misleading health claims, not just on abortion, but on anything from COVID cures to bogus clinics. A ruling is expected by June 2026, and whatever the outcome, it will shape not only abortion politics in the post-Roe landscape, but the balance of power between state investigators and advocacy groups far beyond reproductive rights and for years to come. At stake is not just one investigation, but how far governments can go in probing groups whose views they dislike. If you found this helpful, make sure you're following the show so that you don't miss the next breakdown. Hit follow, tap subscribe, and stay plugged in.